Hello, everyone, and welcome to another Credit Safe webinar. I am happy to have you joining us again for the second of our bankruptcy webinars. As you may have seen on our social media or on our different pages and in our webinars, we've been doing this whole week devoted to the idea of bankruptcy and talking about how that affects business. Today, we're going to be talking about kind of the legal considerations when it comes to business bankruptcy. Now, that being said, please understand we have some very knowledgeable experts on our panel that are lawyers that do know this topic very well. However, we won't be answering any specific to you only questions, nor will any of this take the place of having specific legal advice if you are either a creditor or a debtor in the idea of a bankruptcy claim, a bankruptcy filing. You do need to have a lawyer specific to your case and to work with you. Just want to kind of put that disclaimer out there for everyone as we go through this. Next, as a matter of engagement here, we want you to engage with us. We want you to be able to go back and forth with us today and want to make sure that you have the opportunity to do that. So if you look at the bottom of your screen, whether you have us in full screen or a smaller screen right now, there's a little text bubble option that says Q&A. That's your way to communicate with me. My name is Nathan Kalb, if you haven't figured that out from the screen. And I'll be your host, as I normally am. And I'll be taking those questions and I'll be asking those. I will be asking those at the end. I do have some questions prepared for our panel that are going to start off this discussion. And then I'll be asking those questions. You can ask them at any time. Don't wait till the end. You can ask them. I'll put them in order and I'll go ahead and answer or ask our experts and they can answer them. But that's how you do that. And if you have some other issue or something else comes up, you can communicate with me that way as well. I don't want to take up too much more of the time. So Scott, Ivan, I want to welcome you. Thank you so much for being here with us. And I'm going to take a minute just to allow you, rather than me doing an intro for each one of you, if you guys would do that. Scott, why don't you start first and give us a little bit of a background on you?
Nathan, thanks for the introduction, and thank you all for attending. And I'm an attorney in Southern California where we specialize really in supplier rights. And in particular, we've been working with suppliers and their issues with their customers, especially their insolvent customers, those that either on the verge of or have recently filed Chapter 11 of the Bankruptcy Code. And our mission during this webcast is to work through not only Chapter 11, but the other chapters as well. Ivan?
Good morning, good afternoon. Thank you for having me participate today. It's my pleasure. I am a bankruptcy practitioner and have been doing this only about 36 years. I know I look like I'm in my 20s, but I have been doing it quite a while. I am based in Los Angeles. I'm a partner of a firm known as Manat, Phelps & Phillips, and we have several offices across the country, and we're about 350 lawyers and consultants. And our bankruptcy practice is mostly on the creditor side. We generally do not do debtor cases. And I'm happy to answer questions as the webinar progresses. Nathan, I'll turn it back to you to pose the first question.
Sure. I appreciate it. Thank you, gentlemen. I appreciate you being here and giving up some time from Southern California, both of you, to join us here across the country. And just as one more clarification, folks, we are going to be focusing more on that creditor side of things because that affects more people and it has a bigger effect as we go through here. Not that we'll completely forsake any idea of what's going on with the debtor or what have you, but it is going to be focused more on the creditor as we go forward here. But just to start off, let's talk, if you would, just give me an overview. And I know we talked a little bit beforehand on you guys are going to kind of divvy this up, but what are the various forms, I guess maybe the most common forms or maybe some uncommon forms of bankruptcy here in the United States?
Well, I'll kick off with Chapter 11, and for the attendees, those are your customers from the smallest to the largest that are looking to reorganize. Now, what we're seeing with reorganization under Chapter 11 of the U.S. Bankruptcy Code is more of our customers, especially the public companies that we sell to, whose strategy to exit Chapter 11 is selling everything. And there's a provision under the Bankruptcy Code that allows our customers to sell all of their assets in the opening weeks of the bankruptcy. And that's the trend that we're seeing, especially in this COVID era, where our customers not deemed essential, that may be over leveraged, that are forcing to file Chapter 11, are looking to use the sale of assets strategy under Chapter 11, which many of you attending may be struck as to, isn't that more just a liquidation of the customer's assets in the context of a Chapter 11? That is correct, but that is the trend that we're seeing. Ivan?
Yes, thanks, Scott. My introductory comments are really to go through a checklist of the other forms of bankruptcy. Chapter 7, as many of you may know, is what I sort of refer to as a debtor handing over the keys to its operation to a Chapter 7 trustee. A Chapter 7 trustee is someone who is on a panel that is appointed by the Office of the United States Trustee, and their sole goal is to monetize any assets to the extent there are any assets, and to evaluate claims and pay out a dividend. The reality is many times there are no dividends to pay. And the reality is that many times Chapter 7 cases are filed without any money, without any recognizable assets, and they are the last straw, if you will, for the debtor. One or two quick caveats within the context of Chapter 7, particularly for creditors, is the issue of preferential transfer exposure. And we can go into that a little bit more as we progress in the webinar. But even though you as a creditor may be owed the money, and you as the creditor have been the squeaky wheel and have gotten paid, you should not be surprised if it's enough money that you've been paid that a bankruptcy trustee will look to you to repay or retransfer what has been a preferential payment or transfer. This is a function of bankruptcy law. It's viewed by many creditors as terribly unfair because you are owed the money, but it is something to keep on your checklist. Another form of bankruptcy is a municipal bankruptcy, and that's Chapter 9. Most of you will not see that,
Sure.
except to the extent that these days, with the COVID operations of all cities and municipalities, Chapter 9s may well become a little bit more prevalent because tax revenues are significantly down for municipalities. Chapter 9 also includes special districts. And special districts, if you're not familiar with them, include hospitals, water treatment facilities. So these are subject to Chapter 9.
Okay.
There is a Chapter 12, which relates to family farmers, which I suspect even fewer of you will see.
Right.
There are Chapter 13 cases, which are basically small Chapter 11 cases for wage earners, people who have paying jobs. And finally, there's what's known as Chapter 15, which really relates to foreign bankruptcies and basically is an ancillary product where if there is a bankruptcy or a administration, as some other countries refer to bankruptcy, but there are business operations in the U.S., a Chapter 15 will be filed in the U.S. to effectively complement foreign bankruptcy. So that's a very quick overview without a deep dive into
Sure.
its forms.
Right. I assume that, like many federal documents, the bankruptcy code is, measured by the feet tall that it is from the floor, not how many pages it has. So I'm guessing that we could go quite deep into all of this. But I do appreciate you going through these. It's my understanding that the most common that we see in the business world are chapters 7 and 11. Is that correct?
I think that's right.
Those two. Okay. Now I've heard about another chapter that you guys didn't mention, and I'd love to ask. And Ivan, since you were going through the checklist, let me ask you: what about chapter 22? I've heard of this. What is that?
Well, chapter 22 is not in the bankruptcy code, but
Okay.
it's a repeat bankruptcy. It means a chapter 11 ultimately filed by another chapter 11, and there are even chapter 33s.
Oh, wow. Okay.
Or may seem more and more these days. There are also what are known as chapter 20s. I'm sorry, chapter 18s, which is a chapter 11 followed by a chapter 7 liquidation. So it's just a variation on a theme of recidivism for bankruptcies.
Right. Okay. So a little bit of lawyer tongue-in-cheek type of stuff, if I'm understanding correctly.
I think that's right.
Okay.
And Nathan, if I can jump in on this
Sure,
front,
please, Scott.
because to give some assurance to the credit and finance team attendees, that when your customers do emerge from chapter 11, appreciate that, and especially if they're an operating company exiting chapter 11, what Ivan underscores is that there is still a chance that if that customer, let's say post-COVID, runs into financial difficulty, lender calls the loan, that
Sure.
they can resort to a second chapter 11.
Sure.
In terms of trying to manage credit risk.
Right.
And if I may cut you off also, Nathan.
Sure. Go ahead.
The somewhat state law corollary to chapter 7 is what's known as an assignment for the benefit of creditors. In this day and age, chapter 7, which is a court administered process, may be at times for chapter 7 debtors too transparent and may involve time. There are various states that have good or better or best procedures for what's called an assignment for benefit of creditors, which is basically a company or an enterprise signing over to a pre-selected assignee who will, under sometimes court authority, for example, in Florida oversees all assignments through a court process. California does not. The assignee is charged with, again, monetizing assets and paying claims. The procedure is a little more swift because things can be pre-negotiated, because the company or the enterprise filing the bankruptcy pre-selects the assignee, as opposed to getting a chapter 7 trustee assigned once the case is filed. So you might want to keep your eyes and ears open for what is called an ABC, or an assignment for benefit of creditors, very similar to a chapter 7.
Okay.
Now, Ivan, you had touched on the topic of a bankruptcy preference risk for those companies filing, whether it's chapter 11 or chapter 7. What about in the context of an ABC? Is there preference risk as well for those suppliers?
There is, and preferences. And when clients ask me about preferences, or frankly, as a law firm, we get hit with a preference lawsuit or a preference demand, my reaction is always, it is better to have received a preference or a preferential transfer and have to give some portion of it back than to have never received it at all.
Sure.
And yes, assignees as well as trustees, depending on where they're located and depending on the size, they will pursue preferential transfers. They will also pursue fraudulent transfers.
Okay. So we're getting questions coming in. I'm gonna hold those. So folks, if you see that you've put a question in, you should be able to see on it that it says we're gonna answer that live. Just hang on. We're gonna get to those, but I do have a couple more questions. And what I'm gonna do, Scott, I'm gonna ask you to answer one part of this, and Ivan, I'm gonna ask you to answer the next part. So when we're talking bankruptcy, we've talked a lot about, kind of what it is overview here. Can we look at just the 7 and the 11 and just tell me, Scott, let's talk about the company that's filing. What does that mean for them? What does a 7 and 11 mean for them? And then Ivan, if you can do it kind of on the companies that are affected, those creditors, what in just a minute or, 2, what does that mean for them when they get those things? So Scott, I'll let you go first on the companies that are filing when they've come to that point where they need to file. What's really going on there?
Well, what we're seeing post-pandemic is really a cash crisis for those companies, especially for those companies that are not deemed essential, they're subject to state orders to stay at home and social distancing. As a consequence, these companies have been forced to close and therefore not able to pay their debts. Right. That they have been able to look to the federal government and the Federal Reserve for financial assistance, whether it's through the CARES Act or the Payroll Protection Program. But having said that has been an impetus for many companies, from the smallest to the largest, for filing bankruptcy. And then tied to that as well is the leverage of those companies, those that are not in a position to honor the lender obligations. We see the lenders perhaps initially working with those customers in the context of perhaps filing a Chapter 11. But if those customers don't get that forbearance from a lender, then we do see them filing.
Sure. Okay. Ivan?
Yeah, from the creditor side, my comments really focus on the following. That would be, pay attention. If you get notice of a bankruptcy, pay attention to it. You may not get notice of a bankruptcy immediately, because sometimes creditor lists are not filed immediately when a case is filed. Sometimes it could be a couple of weeks before the initial notice of the filing of bankruptcy goes out from the court. So most of you on listening in and watching are sophisticated in the credit world. So it's important to pay attention to the news and see what's being reported. There are a variety of services that creditors can subscribe to, which generally are the larger cases. But you can also see smaller cases through the news. Then my next comment really, if you are a creditor and there is a bankruptcy and you're aware of it, figure out a quick and early strategy. And as Scott indicated in what he was saying, a lot of these bankruptcy cases, even in the Chapter 11 context, they're being filed these days, are not long reorganization cases. They have very short runways, and things will happen relatively quickly, meaning that you may be a creditor owed on an unsecured debt, and all of a sudden this company is going to be sold or its assets liquidated within a couple of weeks through the bankruptcy court. So pay attention to it early. Get involved in the bankruptcy case early, not necessarily to file a claim, but to get a sense of what's going on. I will also tell you that in some of the larger cases, you can get access to what's going on in the bankruptcy court through various services that are out there, where you can get copies of all of the pleadings essentially for free. For example, there's an entity known as Prime Clerk, which is utilized by a lot of the larger Chapter 11 cases to provide online access to virtually anybody. There's also
Great.
another vendor known as Epic, EPIQ, where bankruptcy cases and the pleadings are out there. So
Okay.
my caveat would be get involved, get some information early, determine if you need to hire outside help
Sure.
in the form of a professional, and pay attention to what's going on as best you can so that you're not caught 2-3 weeks down the road and virtually everything has happened in these cases with a short runway.
Right. Right. And I mean, that leads me right into kind of where we were going next. And I'll let you, if you want to add another thing or two, Ivan, and then we'll go to Scott about what are some good practices? What are those best practices overall? I understand that every case is a little different. Every situation is specific. I understand that. But like you're saying, there are some good practices, some best practices that you can do no matter what's going on. Do you want to add anything to that before I pop it over to Scott? You were kind of giving us a few there. So
Sure. Again, get involved to the extent you know what's going on. Evaluate what your receivable might be. Evaluate what your payments may have been in the 90 days, 120 days leading up to the bankruptcy, so you know whether or not you may have preference exposure. Mm-hmm. Evaluate whether or not the company is going to continue to operate even on a pared down basis, and do they need what your company is providing? For example, a large builder and operator of solar companies called Peterson Dean, which was all over the television and radio airwaves advertising for the last several years, filed bankruptcy. Well, they're still working on projects. They still need supplies. They still need equipment. Are you going to continue to do business with them in the context of a bankruptcy proceeding? Mm-hmm. You need to evaluate that early and be prepared to deal with it.
Sure. Scott, anything that you would like to add to this or that's different in that regard?
Well, Ivan raises all good points. And to underpin that with our customers filing Chapter 11, what we're seeing, especially with our largest companies filing, is a trend to try and qualify those suppliers that they deem essential under a notion of a critical vendor. Mm-hmm. And critical vendor may be an opportunity for suppliers that do have essential trade relationships with those customers to have a portion of their pre-bankruptcy invoices paid. Now, there is a tie-in that they're looking to qualify those vendors as essential with an agreement that supplier provide product or service post-bankruptcy.
Sure.
But from the sales side of your business, who's looking to preserve that relationship, critical vendor may be that opportunity. And we're seeing that more common with the larger companies that are filing Chapter 11. And if that customer does file, let's say, in Delaware or the Southern District of New York, those kinds of requests are common. And the request that the supplier makes is often in the opening days of the bankruptcy. And the leverage that you have if your trade relationship is based on a purchase order and an invoice relationship as opposed to a supply contract is to open that door in the opening days of the bankruptcy and evaluate what the possibilities of qualifying, which includes payments on those pre-bankruptcy invoices in exchange for what your trade credit and credit line would be
right.
qualifying as that critical vendor. So that's one of the kind of key topics that suppliers are looking at with those
Sure.
large customers filing Chapter 11. Nathan?
Absolutely. Not unexpected here. We have a lot of questions that are going to come in, and that was kind of the design of this whole thing, was to ask a few basic questions and get folks talking. We did, just for those folks that are joining us and we're not on our Tuesday webinar, first of all, go check it out, check out the recording. But beyond that, there were some questions that were asked during that the bankruptcy domino effect webinar that we felt were probably better answered in this context with the lawyers and everything, and make sure that these gentlemen knew, we knew they knew a lot more than those of us that were on that previous webinar and wanted to discuss with them. So one of them that was asked before and that I was told I would carry over and that has been asked multiple times here is, are you able to discuss the 503B9 and the idea of the 20-day receipts with us? So maybe Scott, could you give me an idea of what the 503B9 is and kind of what's going on there? And then maybe Ivan, tell us what this 20-day receipt thing is, and so everybody understands and kind of how that all works.
So for suppliers of goods, this is an important provision. And so Ivan talked about transparency and steps the supplier can take upon learning of the customer filing bankruptcy. And that includes the supplier looking at their statement of account and looking at the proofs of delivery for the product that they provided their customers. And so when Nathan refers to this 20-day or 503B9 claim, it's literally that. It's counting back those 20 days prior to the customer filing Chapter 11 and looking at our proofs of deliveries. And it requires physical delivery to that customer within that 20 days. But the notion is that with that POD, you are entitled to a priority claim. The topic then is, when do you get paid upon proving that the debtor did receive your product? And that's an open issue. The Bankruptcy Code does not mandate that your customer pay, let's say, according to invoice terms, but instead when that debtor exits bankruptcy upon confirming a plan. So some suppliers qualifying their 503B9 claims may look to negotiate an arrangement where, in exchange for post-petition trade credit, they will look to have early payment of their 503B9 claim. Ivan, further thoughts?
Well, Nathan, you made a comment early on about how the bankruptcy code is voluminous.
Right.
Actually, the size of the ambiguities in the bankruptcy code are probably larger than the number of pages.
Okay.
This is a somewhat ambiguous area. The drafters of the bankruptcy code didn't answer all of the questions, as they never do.
Sure.
And the practicality of a reclamation claim, of a 503B9 claim, is that while your reclamation claim may be entitled to priority treatment as an administrative priority, waiting until the end of the case to get paid is a problem, because some of these cases never really end, never really have a confirmed plan, and it is not beyond the realm of practicality that some of these cases will see a divestiture of assets through the bankruptcy process and then convert to a Chapter 7. So you may never get paid on your administrative claim as a result of a 503B9 claim. And, it's really a function of what's the most practical thing that you can do to get paid. And the sooner you get paid, in my view, the better. So it's an active area, but it's also a somewhat mushy area of how you deal with it. And if anything is a shout out for a lawyer or a sophisticated lawyer to do that kind of negotiation, this is it, because you may have shipped or provided that service within a week or two of the filing of the bankruptcy, and while a bankruptcy may have been rumored, you were getting assurances that everything was good. So you really need to jump on this and deal with it early and often.
Absolutely. Okay. Well, if as we're going here, folks, again, questions are coming in, and you can keep on going. And if for some reason I butcher your question or you're not quite satisfied with the answer, please go ahead and send it on in, and I will be happy to do that. Next question is, if an LLC is 100% company owned, or I'm sorry, 100% owned, can you look at the partner or the parent if the LLC files Chapter 11 bankruptcy? So again, if an LLC is 100% owned, can you look at the parent company or corporation if the LLC files a Chapter 11 bankruptcy? Whichever one of you would like to take that one. I don't know which of you would be more apt to deal with that. So go right ahead and jump on all over each other and figure out who's going to answer this one first.
Ivan, do you want to start?
Well, the answer to the question is not necessarily. The reality is that LLCs are a way of doing business. Mm-hmm. It's known as a limited liability company. To the extent that it is a separately operated entity, you may not be able to, in effect, view them as one. Mm-hmm. On the other hand, if they are really a conduit through which the parent or the manager or the members do business, there's a much better chance. If they commingle money, if they commingle assets, if it's all the same people, you've got a much better chance.
Okay. Scott, anything to add to that one?
No, that covers it.
Okay. Well, then I'll ask you the follow-up to that one. What if if the parent company or corporation owns less than 100%, 50%, 25%, whatever the number is? Is there any variant there?
In terms of go ahead, Ivan, go ahead.
Well, I was going to say, there's less of a chance getting to the parent if they own less than 100%.
Gotcha. Okay. All right. All right. Let me jump on this next question here. Scott, I'll send it to you first, since you were gracious and gave up that last question. How safe do you feel it is for a creditor to sell to a company post their Chapter 11? I understand collections cannot take place for those invoices pre-bankruptcy, but it was my understanding that the debtor was obligated to pay any post-petition invoices within payment terms.
That is correct. And there isn't the automatic stay that arises with those suppliers and their pre-bankruptcy invoices. Now, having said that, and again, this might tie into this notion of critical vendor and extending terms to customers post-bankruptcy. And the challenge we have in this pandemic is trying to evaluate whether the customers we extend terms to post-bankruptcy are subject to states ratcheting back their openings. And so is there a risk in extending terms to customers that have filed Chapter 11 only to face that those companies might look for what they call a suspension order, where those companies may be forced to close down. And with that closing down for a period of time as a result of the pandemic, is there heightened credit risk for those suppliers selling to those customers? So Nathan, the general rule, as you state, is that suppliers are entitled to be paid according to their terms post-bankruptcy, and if they're not, they can resort to the bankruptcy code to demand payment through a motion. Having said that, there is heightened risk of non-payment for certain classes of customers that have resorted to Chapter 11 as a result of the spike in the virus in many states.
Mm-hmm. Mm-hmm. Okay. I would also add that there is a sense amongst some creditors and vendors that they are not opposed to doing business post-bankruptcy And the reason for that is that let's assume that the debtor has a huge amount of debt, whether it's secured or unsecured debt on its books, and it's got a ton of creditors chasing it pre-petition. Well, post-petition, all of that unsecured debt is frozen. They're not going to have to pay that unsecured debt for a long time, if ever. And the credit decision, which you all may have to make, is, am I better off, in effect, advancing credit to a debtor in possession that doesn't have a lot of debt to pay on a go-forward basis? Am I better off doing that? The other thing to take into consideration is that in the context of a bankruptcy, there is supposed to be more transparency on the balance sheet of the debtor. You know, there are reports that are required to be filed, and you will get a sense of what the true payables are and what the true receivables are of an operating debtor in a bankruptcy. You may not get it in real time, but you're going to get it under penalty of perjury.
Sure. Okay. Well, we are starting to run towards time, and I've got a couple more questions here that I wanna ask. So I know some of these are complex, and there's a lot to answer. If we can just kind of pepper through these with bullet points, maybe that would be best. So the question here is, who initiates the critical vendor status? Can the supplier facilitate this? Is that something that can be done, or is this a court-appointed thing? How does that actually work?
Well, I wish it were left to suppliers to make the demand through a motion with the bankruptcy court, but it is in control of the debtor and the debtor's lender for that filing request. And but having said that, what we are seeing as part of first day filings, again with our larger customers, especially those looking to file in Delaware, is that it's not uncommon to see those critical vendor motion requests. Now, having said that, the practice with those filings is not to actually identify those suppliers that the customer filing Chapter 11 has deemed to be critical. Oftentimes, that's a process where the information may be shared with the creditors committee, but it's not shared beyond that, and the court. But it's often not shared with the entire supply chain, for example, as to who qualifies as that critical or indispensable supplier. Sure.
Okay. Ivan, I'll ask you the next question here. Due to the news reports and everything that we're seeing, I'm going to caveat this question with that. Are we seeing a catch up or a reopening, a growing number in the bankruptcy courts right now? We understand, I'm going to add a little bit. We understand with what you guys have been saying with the pandemic and everything, there's issues going on with that. But are we actually seeing the number of these cases being handled faster now, or are we still dealing with courts being closed and those type of things?
Most of the bankruptcy courts are fully operational.
Okay.
There are some one-off situations where they're not handling hearings, but for the most part, and certainly in the larger settings, the bankruptcy courts are fully operational, and they have been. Mm-hmm. And some of the courts are reopening to in-person appearances. So there's a lot going on, and I would say they're fully operational.
Okay. And the kind of the secondary part to that was, are they doing anything differently to help expedite things at this time?
The answer to that is no.
Okay.
Other than, frankly, the bankruptcy courts and their system of remote hearings is generally far more sophisticated and better than many of the state courts where certainly I have appeared, and the quality of remote hearings is much better. The only thing, and we haven't really touched on this very much, is that there is, in the context of Chapter 11 cases, there's this new subchapter 5 or subchapter V type of bankruptcy, which is a small debtor bankruptcy. when it came into effect in February of 2020, the debt limitation was $2,725,000. And as part of the CARES Act, Congress expanded the debt limitation to $7,500,000. These are small bankruptcy cases that move quicker. There are no creditors committees. There are trustees appointed, and those are likely to move much more swiftly.
Okay. Okay. Scott, anything else to add there on that one?
No, and I think what Ivan underscores with this small business Chapter 11 is that those companies that otherwise might resort to either a Chapter 7 or a state law liquidation, such as an ABC, may have an opportunity to reorganize under this small business Chapter 11.
Great. Great. And for those small business folks out there that or deal with small businesses, something to keep up on, especially with it just happening this year. Not that you haven't had enough to keep up on this year. There's one more thing to kind of pay attention to. So I have one last question, and it's not for you guys. Surprisingly, this one's for me. And I'm just flattered that I get a question in one of these. How can I get a copy of the last webinar? That one's pretty easy. Check your email. Tomorrow, you will be getting an email from me that will give you this recording. It will give you a link to this recording and others. Those others will be in there. You'll be able to see the bankruptcy domino effect. I will make sure that is in that email to you, so that you can do that. You can always get the recordings on our website and on our YouTube channel. And if you're not following us on LinkedIn, we often post clips from these webinars. You'll get all the information. Make sure you do that. Our LinkedIn is just Credit Safe. Look for Credit Safe. You'll see it. You can find me, Nathan Kolb. And I would like to extend that to our amazing experts here and say, hey, Scott, Ivan, is there a way for folks, if they want to ask more, or they want to get a recommendation for you, or they just want to connect with you and just have you kind of available to see what you're posting and everything or putting out? Is there a way for them to connect for our audience to connect with you?
Email works for Scott.
Okay.
And email works for me. My email is the first initial of my first name, Ivan. It's Kallick, Kallick, @Manatt, MANATT.com.
Okay. And I'll make sure that in that email we have both Scott and Ivan's email in there as well. So if you want to send them an email, you can do that afterwards. And that'll all be there. And you'll have my email in that as well. But thank you all so much for joining us. We appreciate it, and look forward to seeing you again soon. Actually, our next webinar is 1 week from today, same time, 2 p.m. Eastern, 11 a.m. Pacific, and we're going to be dealing with COVID, credit, and commercial opportunities, specifically in Southeast Asia. So if you have an interest in that area, you work with suppliers in that area, you sell to that area, whatever, if you have anything going on business-wise in that area, you definitely want to check that out. And the registration for that, again, will be in that email. You'll have an opportunity to register for that, or you can find that on our website. My name is Nathan Kolb. For me and everybody here at Credit Safe, thank you so much for watching. We look forward to seeing you again soon. Thanks, guys. I really appreciate it.
Thank you.
Have a great day, everybody.
Thank you.
Bye-bye.